My name is Silas Allard. I am the Managing Director of the Center for the Study of Law and Religion, and it is my pleasure to welcome you today to this lecture on behalf of the Center. The Center for the Study of Law and Religion is a thought leader dedicated to producing innovative scholarship, facilitating challenging conversations, convening the best minds, and training the next generation of academics, lawyers, and religious leaders to advance the emerging conversation on law and religion. We are proud to have led this field for over 35 years. Today, the Center is home to the leading journal in the field, the Journal of Law and Religion, 2 book series published with Cambridge University Press, Cambridge Studies in Law and Christianity, and Cambridge Studies in Law and Judaism, and a 3rd book series published with William B. Eerdman's publishing company, the Emory University Studies in Law and Religion. We are delighted that the most recent works to publish in the Emory University Studies series are 5 volumes on religious liberty published by our esteemed speaker, Douglas Laycock. In addition to leading works from our book series, Center faculty and research projects have produced over 350 monographs, edited volumes and journal symposia, and hundreds of articles in leading journals in law, social science, and the humanities. For our students, we offer 6 graduate degree programs, dozens of interdisciplinary courses, and skills-building opportunities. The Center also sponsors path-breaking research projects and important public conversations, such as the lecture we are privileged to host this afternoon. I encourage you to learn more about our Center's offerings through our website and by following us on Facebook and Twitter. Today's lecture is the first in our 2019 Harold J. Berman Forum in Law and Religion. This forum, which will continue in March with lectures by Stanley Fish, Jonathan L. Walton, and Mona Siddiqui, explores one of the vexing challenges of our day: how to pursue the common good in an age of diversity and pluralism. How do we make space for difference in our society, and especially in our legal system? How do we mediate the inevitable conflicts of interests, values, and rights? These are not new questions, but the imperative to address them is continually renewed by the necessity of confronting old prejudices, some formerly latent and now overt, others woven deeply into the fabric of our institutions and society. But the imperative to address these questions of pluralism is also renewed by new conflicts over the composition and value commitments of our communities as those communities, both in the United States and globally, continue to change and diversify. One of those conflicts, how the law should treat religion, and specifically those who would object to the law's requirements on religious grounds, is both as old as the United States itself and made continually new by changes in religious demography and social norms. So we begin this Berman Forum inquiry on pluralism and the common good with the old question made new, the question of the religious exemption. We are very fortunate because there are few people as knowledgeable and well-regarded on this topic as our lecturer, Professor Douglas Laycock. Professor Laycock is Robert E. Scott Distinguished Professor of Law and Professor of Religious Studies at the University of Virginia. He is also Alice McKean Young Regents Chair in Law Emeritus at the University of Texas Law School, where he is currently teaching. Professor Laycock is the nation's leading authority on the law of religious liberty. In addition to 4 decades of writing and teaching on the subject, Professor Laycock has testified frequently before Congress and has argued many cases in the courts, including in the United States Supreme Court, where he has served as lead counsel in 6 cases. No conversation on the law of religious liberty is complete without weighing the opinion of Professor Laycock. Professor Laycock's immense scholarship on these topics has, as I said, recently been published in 5 volumes under the title Religious Liberty as part of the Emory University Studies in Law and Religion series at William B. Eerdmans Publishing Company. No academic or legal library in law and religion will be complete without these volumes. In addition to being the country's foremost expert in religious liberty, Professor Laycock is also an expert in the law of remedies, first vice president of the American Law Institute, and a fellow of the American Academy of Arts and Sciences. Please join me in warmly welcoming Professor Douglas Laycock to Emory University School of Law.
Thank you, Silas. This may be a bit exaggerated, but I'll take it. So as most of you know, in Masterpiece Cakeshop, the Supreme Court held that, at least on the facts there presented, a wedding baker who conscientiously objected to doing a wedding cake for a same-sex wedding ceremony, who consciously objected, didn't actually have to make the cake. He could be exempted. The decision has been widely described as a very narrow decision on an odd set of facts. And my central claim today is that the opinion actually has much broader implications than have generally been recognized. I do not mean merely that a narrow judicial opinion creating a right may often evolve into a much broader right, although that is certainly true. And I do not mean merely that Justice Kavanaugh is likely to be more sympathetic to religious liberty and less sympathetic to gay rights than Justice Kennedy would have been, although that's probably also true. What I mean is that the Masterpiece opinion as written, combined with a bit of savvy lawyering on the part of those representing conscientious objectors, logically leads to a general protection for conscientious objectors, at least in religiously important contexts such as weddings. Let me make my own position clear at the outset. Since marriage equality first came on the national scene in 2004, I have advocated for marriage equality with religious exemptions. Full legal protection for same-sex marriages, with exemptions to protect nonprofit religious organizations from having to celebrate or recognize those marriages, and with exemptions for very small for-profit businesses from having to assist with the wedding or its celebration, so long as other providers of the same goods or services are readily available. The solution to this conflict is to protect the rights of each side, the right of both same-sex couples and the right of conscientious objectors to live their own lives by their own deepest values in accord with their deeply felt identity. And as I and others have explained elsewhere, they make fundamentally similar claims on the larger society. Government should not interfere with sexual orientation, and it should not interfere with the exercise of religion without the most compelling reasons. And the Masterpiece opinion doesn't go that far, but it is consistent with that view. The court set the right tone, speaking of the necessity to respect the rights and dignity of both sides. It said, and I'm quoting now, "Gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. The exercise of their freedom on terms equal to others must be given great weight and respect by the courts. And at the same time, the religious and philosophical objections to gay marriage are protected views and in some instances protected forms of expression. The Civil Rights Commission was obliged under the Free Exercise Clause to proceed in a manner neutral toward and tolerant of Phillips's religious beliefs. The Colorado Civil Rights Commission and the Colorado Court of Appeals had failed to treat the bakers' religious commitments with either neutrality or respect, and their obvious bias violated the Free Exercise Clause in the view of 7 justices. This bias was manifested in hostile comments and an unequal treatment of customers and bakers on opposite sides of the moral debate over same-sex marriage. Savvy officials can suppress their hostile comments, but savvy conscientious objectors can smoke out unequal treatment by sending testers to request goods and services that retailers who support same-sex marriage are likely to refuse. And a state that protects these liberal retailers while penalizing religious conscientious objectors violates the Free Exercise Clause under Masterpiece and unreasonable readings of the court's recent free exercise precedents. Now, any deeper analysis of Masterpiece has to begin in 1990 with Employment Division versus Smith. And I'm going to spend some time there, but trust me, I'll eventually get back to Masterpiece. The Smith case changed the law of free exercise in important ways, but 29 years later, the meaning of that change is still unsettled. Mr. Smith consumed peyote at a worship service of the Native American Church, where the central religious ritual is the consumption of peyote in a highly structured ceremony under the supervision of a religious leader, the peotero. Hallucinogenic drugs have been used for religious purposes throughout human history and all around the world. Peyote is a naturally occurring hallucinogen. You don't smoke peyote, you eat it. You eat the bud of a cactus plant. It is tough, it is hard to chew, it often causes nausea and vomiting. So there's never been a big recreational market for peyote. But American Indians were using it for religious purposes when the first Spanish explorers arrived, and probably for millennia before that, and they still are. The Native American Church teaches total abstention from all other drugs, including alcohol. It is generally viewed as a positive influence on its members. Religious use of peyote by the Native American Church had long been exempt from the federal drug laws, and after the court's decision in Smith, Congress extended that protection to all American Indians and preempted all contrary state law. Smith was fired when his supervisor learned that he had attended the peyote service. He did not sue over his discharge, but he did apply for unemployment compensation. And the Supreme Court had repeatedly held that workers were entitled to unemployment compensation when they lost their job for religious reasons, for refusing to work on the Sabbath, for refusing to make weapons. The relevant legal rule came from two leading cases, Sherbert versus Werner and Wisconsin versus Yoder. Sherbert and Yoder held that government could not burden a religious practice unless the burden was necessary to serve a compelling government interest. So, for example, government could refuse to exempt people who conscientiously objected to paying taxes, a very convenient conscientious belief, but there was no such compelling interest in withholding unemployment compensation from workers with religious practices that conflicted with their employer's demands, or even in an extra year or two of formal education for Amish children. In Smith, the state claimed a compelling interest in a no-exceptions drug enforcement policy. Smith replied that the tightly controlled religious use of peyote was not dangerous to anybody, and the state's interest was nowhere near compelling. That is how the case was argued, but the Supreme Court did not resolve that disagreement. Instead, and without being asked, Justice Scalia said the state didn't have to show a compelling interest at all. If the law was neutral and generally applicable, a phrase he used repeatedly but never defined, it could be applied even to the central ritual of a worship service. The opinion appears to say that if the law is neutral and generally applicable, the state doesn't have to have any reason at all for refusing a religious exemption. It can just say no. Smith was 5-4, the work of 4 conservatives plus Justice Stevens. The rhetorical tone of the opinion was hostile to religious exemptions. And lower courts initially said that pretty much any law is neutral and generally applicable, even a zoning law that categorically excluded churches. The city had a reason for excluding churches that was more than just hostility to churches, so according to the Eighth Circuit, the law was neutral and generally applicable. But Sherbert and Yoder, the earlier leading cases, were not overruled. Scalia had only 5 votes. It is a reasonable inference that one of those 5 said he couldn't overrule anything. So Sherbert and Yoder were distinguished and given new explanations. Yoder had held that Wisconsin could not require the Amish to send their children to high school. Scalia claimed that Yoder was based on a hybrid of free exercise and the parents' right to control their children's education, an unenumerated right which Scalia didn't believe in, but convenient for the day. More fundamentally, this hybrid rights theory seemed to assume that if you combined a failed parental rights claim with a failed free exercise claim, somehow the 2 failed claims added up to a successful hybrid claim. That never made any sense, and almost nothing has come of the hybrid rights theory. The more important reinterpretation was what Scalia said about Sherbert versus Werner. That was the first of the unemployment compensation cases. He said the unemployment law in Sherbert was not neutral and generally applicable because the state accepted, quote, at least some reasons for refusing available work. You don't forward unemployment compensation if you decline a job far beneath your skill level or 200 miles from your home. You don't have to work in a strip club or a massage parlor. There weren't many acceptable reasons for refusing work and demanding a government check instead, but there were at least some. And because the state accepted some secular reasons for refusing work, it had to also accept religious reasons. Mrs. Sherbert was still constitutionally entitled to her unemployment compensation even after Smith. The implications of that reasoning were initially concealed by the opinion's hostile rhetoric about exemptions. But think about it. If a law with even a few secular exemptions isn't neutral and generally applicable, then not many laws are. Exceptions grease the wheels for legislation. Legislators often exempt their friends and contributors. They exempt interest groups that might be strong enough to block passage of the law. There were no exceptions to the law banning peyote, but such across-the-board total prohibitions are actually fairly unusual. If a law that burdens religion is not neutral or not generally applicable, it still has to be justified by a compelling government interest. And Smith's discussion of Sherbert versus Werner suggested that not many laws are neutral and generally applicable. The court returned to the issue in 1993 in Church of the Lukumi Babaluaye versus City of Hialeah. Santeria is a Cuban religion that combines elements of Catholicism with elements of Yoruba religion from West Africa. Its central ritual is the sacrifice of small animals. There were an estimated 50,000 Santerians in South Florida, mostly practicing in secret. When the Church of the Lukumi proposed to take the faith public, Hialeah passed 4 ordinances to prohibit animal sacrifice. They were drafted to ban Santeria without affecting any of the other myriad reasons why humans kill animals. It was a crime to unnecessarily kill an animal in a ritual or ceremony, not for the primary purpose of food consumption. The city said that was neutral and generally applicable. No one could sacrifice an animal under that definition. But of course, the definition was gerrymandered to get only Santeria. The church had not gotten a single vote in the lower courts, which highlights how Smith was initially received. The Supreme Court reversed 9-0. The ordinances were not neutral, they were not generally applicable, and the court said they didn't come close. The court discussed neutrality and general applicability separately, in separate numbered sections of the opinion. It still did not define either term. It discussed neutrality in terms of targeting religion, the purpose or object of the law, and discrimination because of religion. But none of that language appeared even once in the section on general applicability. Instead, the court applied what amounts to a standard. The city had said that animal sacrifice undermined government interests in public health and in protecting animals. But the ordinances failed to regulate other activities that undermine those same interests to the same or greater degree. And not just other killings of animals, the most obvious analogy. The city's health officer admitted on cross-exam that the garbage dumpsters of restaurants were a bigger health hazard than the remains of sacrificed animals. But one was banned and the other was not. So the ban on sacrifice was not generally applicable. It was an element of the offense that the killing be unnecessary, and the city said that religious killings were unnecessary. Of course, they're unnecessary only if the religion is false, which is plainly what the city believed. But no American government gets to decide which religions are true and which religions are false. The Supreme Court didn't say that. It made a different point of potentially broader application, that when the city said that secular killings were necessary and religious killings were not, it, quote, devalues religious reasons for killing, judging them to be of lesser import than non-religious reasons. So once again, if you take the court's reasoning seriously, many laws will fail the test of general applicability. Many laws that burden religion will still require compelling justification. Anytime the government prohibits a religious practice, but exempts some analogous secular practice that undermines the same alleged government interest, it decides that the secular practice is more important, more valuable, more something that makes it more deserving of exemption. The government devalues the religious practice as compared to the analogous secular practice. Now, I do not claim that the court understood or consciously intended all of this in Smith or even in Lukumi. Neutral and generally applicable law was an undefined, intuitive concept in Smith. A criminal prohibition with literally no exceptions was generally applicable if anything is. So the court had no occasion to examine the concept or clarify its intuition. Lukumi made clear that Smith had not repealed the Free Exercise Clause, and that the requirements of neutrality and general applicability had enforceable content. But Lukumi was at the other end of the continuum from Smith, with laws that were obviously neither neutral nor generally applicable. So the court, as it said, need not define with precision the meaning of general applicability. But the rule that secular exceptions generally require religious exceptions is not some creative reinterpretation dreamed up years after the opinions were issued. The requirement was there in Smith itself, if one read carefully. Smith unambiguously concluded that the unemployment compensation law in Sherbert did not qualify as neutral and generally applicable, and much followed from that conclusion. I noted the two opinions at the time, and I'm going to quote a bit of my earlier writing because I've recently been accused of having made all this up 25 years after the fact. I read the rhetoric in Smith in a 1990 article to create a general rule of no exemptions, and then the many limitations on that rhetoric in Smith as creating enough exceptions and limitations to swallow most of the new rule. If the exceptions and the limitations were not taken seriously, then I said Smith created the legal framework for persecution. But if the court were serious about the limitations and exceptions, then much religious exercise could still claim judicial protection. And in particular, quoting now, in such individualized decision-making processes, the court's explanation of its unemployment compensation cases would seem to require that religion gets something like analogous to most favored nation status. Religious speech should be treated as well as political speech. Religious land uses should be treated as well as any other land use of comparable intensity, and so on. And the other point in the court's explanation of its unemployment compensation cases is secular exemptions. If the state grants exemptions from its law for secular reasons, then it must grant comparable exemptions for religious reasons. The requirement that religious conduct get the benefit of secular exemptions is a requirement of broad potential application. Exemptions for secular interest without exemptions for religious interest reflect a hostile indifference to religion. Such a discriminatory pattern of exemption shows that the legislature's goals do not require universal application, and that the legislature valued the exempted secular activities more highly than the constitutionally protected religious activities. The pattern of exemptions reflects a legislative judgment that the free exercise of religion is less important than the demands of some special interest group of no constitutional significance. But that is a judgment inconsistent with the constitutional guarantee. That's in the Supreme Court review in 1990. You can look it up. All those implications were there from the beginning, but few seem to notice. Between Smith and Lukumi, lower courts gave no weight to Smith's limitations and exceptions. After Lukumi, that began to change. But on its facts, Lukumi was an extreme case. The ordinances were clearly enacted to suppress a single religious practice. And government lawyers still argue that every law is neutral and generally applicable except for a few laws so extreme as the ordinances in Lukumi. And a few lower courts have actually attended to the issue and then agreed with the government. But more courts have concluded that even one or a few secular exceptions, if they undermine the interests the law is alleged to protect, show that the law is not generally applicable. So Newark had a rule that police officers must be clean-shaven, with a medical exception for officers with skin conditions that made it difficult to shave. That was it, only one relevant exception. But the Court of Appeals said that Newark had to also exempt Muslim officers who were religiously obligated to grow a beard. Newark had made a value judgment that medical needs were more important than religious needs. And that value judgment is what Smith and Lukumi forbid. The Newark opinion in the Third Circuit was written by a judge you may have heard of, Samuel Alito. There are 9 or so similar decisions in courts around the country. Which at last brings me back to Masterpiece Cakeshop. Masterpiece is one of a handful of cases where conservative Christians in the wedding business refuse to assist with a same-sex wedding and get sued under a state public accommodations law. These vendors understand marriage as an inherently religious relationship, and therefore they understand weddings as inherently religious events. Jack Phillips, the owner and cake artist in Masterpiece, testified to this understanding. He cited various scriptural bases for marriage, and he concluded that his objection has everything to do with the nature of the wedding ceremony itself and my religious belief about what marriage is and whether God will be pleased with me and my work. The The issue was the nature of the event and that I cannot participate in such a ceremony based on my sincerely held religious beliefs. The wedding vendor's job is to make their part of the wedding the best and most memorable it can be. They understand themselves to be promoting and celebrating the wedding and the marriage, and they say they cannot do that. The Washington florist, sued in a similar case, had happily served her longtime gay customer for years, knowing that the flowers were for his same-sex partner, but she said she could not do the wedding. To believers like these, the wedding is a religious event that is religiously prohibited. It is a sacrilege, and they cannot participate. These cases have mostly been litigated under state law protections for religious liberty. They have mostly been in blue or purple states, because those are the only states with statewide gay rights laws. And the religious claimants all lost. A wedding photographer in New Mexico, a baker in Oregon, the florist in Washington. Other cases, some of them arising under ordinances enacted by blue cities in red states, are still pending in the state courts. Masterpiece arose in Colorado, which has no statute protecting religious practices from the state and no state Supreme Court decision interpreting the free exercise clause in the state constitution. So federal claims played a larger role in Masterpiece. The Masterpiece baker, Jack Phillips, claimed that his cakes were works of art protected by the free speech clause. And if you look at the pictures of his cakes, that is not a crazy claim, but it has no logical stopping point. If cake decorating is speech, lots of businesses may involve elements of speech. His lawyer was also arguing the Washington case that flower arranging is speech. And at the oral argument, she had great difficulty persuading justices that she could draw a defensible line between products that were speech and products that were not. Phillips also had a federal free exercise claim. But for that, he had to show that the Colorado law was not neutral or not generally applicable. And his lawyers obviously doubted whether he could show that. They gave much more attention to the free speech claim than to the free exercise claim. No one sympathetic to the state and the same-sex couple took the free exercise claim seriously. A prominent law professor on a listserv that I'm not permitted to cite said the court would reject the free speech theory and then dispose of the free exercise theory in a paragraph. That widespread disdain for the free exercise claim resulted from the rhetoric of Employment Division versus Smith, still dominating close textual analysis of the Smith and Lukumi opinions. Now, I frequently collaborate with Tom Berg at the University of St. Thomas in Minnesota. He and I filed an amicus brief devoted solely to free exercise. We argued for an exemption only for small businesses and only for events directly related to the wedding. The focus on religious context would lead to a much narrower exemption than the free speech theory, which would have protected simple bigots in all contexts, as well as those with sincere religious objections in religious contexts. The Colorado Public Accommodations Law had no explicit secular exceptions, but we said that it had been enforced in discriminatory ways that created an implicit secular exception, and this secular exception meant that the law was not generally applicable. The court did not say that, but it relied on much of the same evidence to say something that led to nearly the same place. It said that the law was not neutral because Colorado's enforcement pattern showed hostility to religion. One of the civil rights commissioners had made hostile statements on the record, blaming religious liberty for slavery and the Holocaust, and calling Jack Phillips's religious commitments despicable. Views of that sort are actually very widespread, but public officials have now been warned not to talk about them. And so those facts may not recur. The other evidence is more important. A Christian activist named William Jack went to 3 different bakers requesting cakes with scriptural quotations hostile to same-sex marriage. Some of the messages were offensive by modern standards. Each baker refused to make his cake. He charged him with religious discrimination, and the Civil Rights Commission dismissed the charges. Now, the same Colorado law that prohibits discrimination on the basis of sexual orientation also prohibits discrimination on the basis of any religious practice or belief. So the Colorado courts had to explain why the Masterpiece baker violated the statute and the other bakers did not. And in the course of doing that, the Colorado Court of Appeals said some deeply inconsistent things. Most fundamentally, it said that refusing to make a cake closely associated with same-sex couples discriminated on the basis of sexual orientation. But that refusing to make a cake closely associated with conservative Christianity did not discriminate on the basis of religion. For the protected bakers, the court assumed that the message of the cake would be the baker's message and not just the customer's. The protected bakers could lawfully object to, quote, the offensive nature of the requested message. For Jack Phillips, the court said that a wedding cake wouldn't send any message, but if it did send one, it would be the customer's message and not the baker's. The protected baker's willingness to make cakes with other Christian themes for other Christian customers was treated as exonerating. Phillips's willingness to produce other cakes and baked goods for same-sex couples was treated as irrelevant. For Jack Phillips, the fact that he would be merely compliant with the law meant that he would send no message. For the other bakers, that argument went unmentioned. The court also said that in the cases it distinguished, the customer wanted objectionable words or symbols on the cake. And in Jack Phillips's discussion with a same-sex couple that sued him, he did not learn what they wanted on their cake. That argument has been picked up very widely on the same-sex couple's side of the debate. Some academics even claim there is consensus that the baker could not be required to write any explicit message on a cake. There is no such consensus, and that argument is deeply disingenuous. In the actual transaction, Phillips could surely assume that the couple wanted some words or symbols on their cake, and an essential part of his task, he testified, was to help them choose those words and symbols. In any event, the very purpose of a wedding cake is to celebrate the wedding and the marriage with or without an inscription. As the Colorado court said, in the course of ruling against him, the couple asked Phillips to design and create a cake to celebrate their same-sex wedding. And under the rest of the Colorado court's opinion, the case would have come out the same way even if the conversation had lasted longer and the couple had said they wanted two men in tuxedos or David Hart Charlie or a rainbow or any other more explicit message. The court's logic would still have said that it would be the customer's message, not the baker's, that Phillips would merely be doing what the law required, and that refusing to produce a message so associated with same-sex couples discriminated on the basis of sexual orientation. I do not believe for a minute that the Colorado Civil Rights Commission or the Colorado Court of Appeals would rule any differently in a case where the customer requested an explicit message. And most fundamentally, I don't believe it because if refusing a cake with an explicit message is protected, then the conscience subjectively bakers basically win. You just need to know enough law to keep the conversation going until the explicit message is chosen or revealed. Protection for explicit messages would not be much help to florists or wedding photographers, but it would largely solve the problem for wedding bakers, and the gay rights side of this debate is not going to settle for that. Even if the Colorado court's distinctions were more persuasive, even if they succeeded in placing the two bakers in different doctrinal categories under state law, that would not change the bottom line. The bottom line here is the conscience of bakers who support same-sex marriage or refuse to oppose same-sex marriage is protected. The conscience of bakers who object to same-sex marriage is not protected. The discrimination is like the ordinance in RAV versus City of St. Paul, where racial epithets were illegal, but racist, bigot, and a vast range of other offensive epithets were permitted. State law placed the two sets of epithets in different doctrinal categories. The correlation between epithets hurled and speakers and viewpoints regulated was imperfect, but those distinctions could not save a regime in which a regime that effectively licensed one side of a debate to fight freestyle while requiring the other to follow Marquis of Queensberry rules. And for the young people in the audience, Marquis of Queensberry's provide boxing gloves, can't hit below the belt. Freestyle doesn't have those rules. That's what it was about. It is no more defensible for Colorado to allow one side to follow the dictates of conscience while requiring the other side to surrender its conscience to any customer who walks in the door and asks. The Supreme Court did not invoke RAV, and it did not rely on all the evidence I've outlined, but it relied on important parts of it. It noted the inconsistency about whether any message would be the baker's message or the customer's message, and the inconsistency about the baker's willingness to provide other goods and services to protected classes. And it focused on the Colorado court's statement that the protected bakers could refuse to provide the offensive message that William Jack requested. And it said a principled rationale for the difference in treatment of these two instances cannot be based on the government's own assessment of offensiveness. Now, much of the commentary has treated the court's decision as confined to an odd set of facts and is avoiding the underlying question of whether religious wedding vendors can be required to assist with same-sex weddings. but these facts are readily reproducible. Wedding vendors seeking exemptions can send testers like William Jack to request an offensively conservative religious version of the same goods or services. And we can confidently expect state enforcement officials to react just as they did in Colorado, protecting the conscience of the vendors they agree with. And if liberal business people don't have to provide conservative religious goods or services that they find offensive, then the masterpiece opinion says conservative believers don't have to do same-sex weddings that offend their conscience. This means the Supreme Court has gone much further than is generally recognized toward protecting wedding vendors, and it has taken a substantial step towards the protective understanding of Employment Division versus Smith, that even one or a few secular exceptions make a law not neutral or not generally applicable. If the law is not neutral or not generally applicable, religious conscience objectors are still entitled to an exemption unless there's a compelling government interest in requiring them to comply, and the state's willingness to grant secular exemptions seriously undermines any claim to a compelling interest in enforcing the law without exceptions. But this requirement to treat claims consistently will be powerful only if the courts take it seriously. States will try to manipulate their rules to justify unequal treatment of objectors they agree with and those they don't. In Masterpiece, 4 justices accepted such a manipulation. Justice Kagan's concurrence and Justice Ginsburg's dissent both argued that the state's discrimination could have been justified on the ground that the protected bakers would not sell an anti-gay cake to anybody, but Phillips would sell wedding cakes to opposite-sex couples. But as Justice Gorsuch's concurrence explained, this reaches the preordained result by manipulating the level of generality. It treats the anti-gay cake as having a distinctive message, but the pro-gay cake, the cake for the same-sex wedding, is merely generic. If the anti-gay cake is a unique product because of its message, then the category is not cakes, or even wedding cakes, but cakes with a particular message. And as I said, often a cake for a same-sex wedding will have some indication, even if symbolic, indicating approval of the marriage. 2 brides, a couple's names, a rainbow. That is a cake that Jack Phillips would not sell to anybody. And even without just symbols, the cake still sends a celebratory message. Here's another way to think about the same point. The attempt to rationalize what Colorado did treats an anti-gay cake and a gay pride cake as 2 different products, different because of their different messages. And the protected baker wouldn't make one of those products for anybody. But it treats the same-sex wedding cake and the opposite-sex wedding cake as the same product, distinguished not by their different messages, but only by the identity of the customer. We come back to the same basic contradiction. The Colorado courts and the liberal justices treat Jack Phillips as making a decision about the customer, but the protected bakers as making a decision about the message. Now, Colorado, and at least some gay activists in Colorado, remain determined to get Jack Phillips. He reports his store has been vandalized, he's received death threats and countless hateful phone calls and emails, and he's received repeated requests for cakes that purported customers know he will not make. Cakes honoring Satan have been a very popular request. One such test order came in on the day the Supreme Court agreed to hear his case. It would not have served the tester's purpose to order a wedding cake because to avoid further penalties, Phillips no longer makes wedding cakes. He gave up 40% of his business and 40% of his income and laid off most of his employees to follow his conscience. And the person calling knew all that. She is a lawyer who reports on her website that she takes great pride in suing businesses that discriminate against the LGBT community. So she asked for a cake that was blue on the outside and pink on the inside, and she said it was to celebrate her gender transition. Phillips said he could not make that cake. She filed a complaint with the Civil Rights Commission, which is how we know her identity. And 3 weeks after the Supreme Court's opinion, the commission's director found probable cause to believe that there had been a violation. Now, this new case is a step beyond the Supreme Court's decision in one way that seems important to me. It does not involve a wedding. There is no religious equivalent to a gender transition celebration. I think that Phillips should still be protected, but for me, this is a somewhat harder case than a wedding case. It may be no harder for the court because the court made very little of the fact that Phillips understands a wedding to be a religious context. The gender transition cake is still a demand that Phillips commit his talents to celebrating something deeply at odds with his religious faith. And his claim of conscience is still narrowly focused on a particular celebration. Narrow focus goes to the argument about compelling government interest. An exemption for merchants who refuse to serve gays or transgender persons at all, or in a wide range of transactions, would inflict much more harm on the LGBT community. It would threaten frequent denials of service instead of very occasional denials in a few religiously sensitive contexts. An exemption for celebrating gender transition celebrations would not threaten widespread refusals of goods or services. So I still think that the state's interest in this narrowly focused claim is less than compelling. And enforcement of the Colorado law is still discriminatory. Colorado has not abandoned or repudiated its position in the William Jack cases. It is apparently still the state's position that secular bakers with views the state agrees with do not have to make cakes they find offensive, but conservative religious bakers with views the state disagrees with do have to make cakes they find offensive. So the law still is not generally applicable. It is still administered with hostility to religion, and so is not neutral in the court's view under the Masterpiece opinion. Either way, the compelling interest test still applies. If the Colorado courts enter another order against Jack Phillips, there will be another cert petition. Justice Kennedy will no longer be there. Justice Kavanaugh will be. With Kennedy's retirement, there is no one left from the court that decided employment division versus Smith. And there has been a generational transition in the conservative legal movement. The modern conservative legal movement began in reaction to the perceived activism of the Warren Court. It emphasized deference to the political branches, and that was the theme of the Smith opinion. Scalia was not hostile to religion. He was very devout. He was hostile to the judicial balancing of interests inherent in the compelling interest test. Better that small religions be disadvantaged, he said, than that judges balance the believer's interest in every religious practice against the government's interest in regulating that practice. Scalia plainly envisioned that the victims of his decision would be small religions and idiosyncratic practices. He did not foresee that our largest religions, his religion, would need the protections of religious liberty for moral teachings of great importance to them. Both of those things have changed. Today's conservative judges are as activist as the Warren Court ever was. Decades in the judicial majority can lead you to believe judicial activism is a good thing. If you have the power, you will eventually decide to use it. And in the highly visible culture war cases, the victimized religions today are conservative Christians, Catholics and evangelicals most frequently. The court's conservatives have vigorously enforced the Federal Religious Freedom Restoration Act, most notably in the contraception cases. And if Masterpiece returns to the court in the carefully contrived case of the gender transition cake filed on the day or ordered on the day cert was granted in Masterpiece, the conservatives are likely to see persecution of Jack Phillips, a concerted effort to force him to surrender his faith or surrender his business. They will want to protect him with a clear rule that states cannot misinterpret or evade. Some religious conservatives now look forward to Smith being explicitly overruled, and 4 justices invited that request in a recent opinion concurring in denial of certiorari. That could happen. But Masterpiece points the way to what I think is more likely. The court will build up the protective parts of Smith, the requirement that laws burdening religion be truly neutral and truly generally applicable. Any secular exception that undermines the interest offered to justify regulation of religion will show both that the law is not generally applicable and that it serves no compelling interest. Such an exception that violates general applicability, those exceptions may be explicitly written into the law, or they may emerge as a matter of interpretation. It may be labeled as an exception or as a gap in coverage, or simply as a claim that one side violated the law and the other side didn't. Masterpiece gets most of the way there. Its emphasis on the state's hostility to Phillips's faith did it the hard way. It means that those working to minimize the holding can still read it as a motive case. But that hostility was inferred partly from the comments and largely from the objectively unequal treatment of Phillips and the other bakers. It's a very short step to make that focus on objectively unequal treatment even more explicit, to make objectively unequal treatment dispositive, whether or not the fact finder draws an inference of actual hostility. Colorado may soon give the court an opportunity to do all that. That would lead to much better protection for religious liberty, and that would be a good thing, not just for wedding vendors, but for a broad range of cases. Do not assume that this battle over legal doctrine is only about abortion, contraception, and same-sex weddings. Culture war cases grow out of deep moral disagreement about matters relating to sex, and they get all the headlines, but they are not the typical cases. The typical case about religious exemptions in the lower courts involves Sabbath observance, grooming rules, Amish buggies, unnecessary autopsies, churches feeding the homeless, or some other random conflict between pervasive regulation and diverse religious practices. They mostly involve the small religious minorities that Justice Scalia thought he was disadvantaging in Smith. And then there is Mary Steinmetz, the Kansas woman who died for her faith in America in the 21st century. She was Jehovah's Witness, she could not accept a blood transfusion, and she needed a liver transplant. Bloodless liver transplants were available in Omaha, and they were actually cheaper than any transplant hospital in Kansas. But Kansas Medicaid had a rule: we don't pay for out-of-state medical care. It claimed that rule was neutral and generally applicable, although I think it really wasn't. She sued under the state constitution, and she eventually won, but by then it was too late. Her medical condition had deteriorated to the point that she was no longer medically eligible for a transplant. She died soon thereafter. That's an outcome of a regime with no religious exemptions. Religious liberty reduces human suffering, it reduces social conflict. It is one of America's great contributions to the world. We should not let it slip away, either in legal wrangling or in a bitter culture war. And the Supreme Court's opinion in Masterpiece is an important step toward restoring federal constitutional protection for religious liberty. Thank you all for listening.
Thank you, Professor Laycock, for opening up this potential new world, maybe not a new world, but a reimagining of an old world that Masterpiece moves forward. Professor Laycock has agreed to take some questions. We have microphones at the front of each aisle, so please, if you have a question, queue up at one of the microphones, and we've got a good 15 or 20 minutes for questions, so plenty of time. I invite you forward.
Talking about distinctions between Masterpiece and other public services, how should we distinguish between public services based on the type of service they provide and the availability of that service? So in Masterpiece, if you have cakes that are a relative luxury, all things considered, for a public service, as opposed to a public service that provides, say, health care, an arguably more necessary service, should the more necessary service be required to serve people more easily despite the religious convictions of either party? And similarly, if cakes are available from multitudinous shops in an area and purchasing them is optional, while contributing to the healthcare system is mandatory and your choices are limited, how should we balance these different public services?
Well, the point of your question is that the state's interest in requiring health care is much more important than its interest in requiring cakes. But I think, in fact, there's a compelling interest in ensuring access to the market system, whether we're talking about cakes or about health care. So if there are no other bakers available, I would say Jack Phillips has to make this cake. In fact, in metropolitan Denver, there were many bakers available, and the couple was immediately given a free wedding cake. The health care issue is important. And it obviously arises with respect to the same cluster of issues related to sex, contraception, abortion, in vitro fertilization. For the most part, those don't arise in emergency circumstances where there's no choice of hospital, but increasingly, especially in smaller and middle-sized cities, there's one hospital with a monopoly, and if that's a Catholic hospital, services may well be unavailable. And this position irritates my friends on the religious exemption side, but Catholic hospital with a monopoly should have to provide the services. And that won't mean they would provide the services, it would mean they would give up their monopoly. They would contract out reproductive health care to somebody else in the community. But whether it's health care or cakes, the service has to be available somewhere, in my view.
Thank you.
Who else?
Hi, Professor. Thanks for coming. I have a question about, it sounds to me like you think that if the Jack cakes are exempted, then the Phillips cakes should be too. Either both of them are allowed or both of them are not allowed.
Right.
I wanted to ask, though, do you think that since religious freedom is specifically provided for in the Constitution, that if anything, that you could have a case where the Phillips case actually would be exempted, but not the Jack cakes? Basically, that is the religious freedom, does that carry more valence than these civil rights claims that came to us out of, penumbras or fundamental rights jurisprudence?
Yes. So, the relevance of the William Jack cakes is all a product of Smith. Right? Smith creates this requirement that in order to get a religious exemption, you have to show the law is not neutral and generally applicable. And in Masterpiece, they did that by pointing to the bakers who were exempted from providing cakes with Leviticus on the top. But, yeah, I've believed from the beginning Smith was wrongly decided. You shouldn't have to go through all of that to show that you're entitled to religious exemption. The Sherbert-Yoder rule was a much better rule. If a religious practice is burdened by the state has to show a compelling interest. If we went back to that rule, if Smith were overruled, then the William Jack cakes would become irrelevant. And Phillips would be entitled to an exemption, whatever the state did about William Jack. That would be much simpler to administer. I think it would clearly be more protective of religious liberty. I think it would be a better rule. Forced to work in a world of employment division versus Smith, I think what Smith says about Sherbert versus Werner and what Masterpiece says about the unequal treatment on these facts point the way to protecting a lot of religious liberty even under the Smith regime. But the litigation will always be more complicated. It will always turn on identifying some comparative case and persuading a judge that that comparative case is the right analogy and so forth. So yeah, it'd be better to get rid of Smith, but the William Jack cases are essential to arguing under Smith.
Thank you very much for your lecture, Professor Laycock. In matters like Masterpiece Cakeshop, it seems an issue in the background is, are anti-discrimination ordinances that protect the LGBT community treated differently from other kinds of anti-discrimination ordinances? For example, ones about race. So maybe you could just speak to that. That is, the example that's often brought up is about what about if you refuse to bake a cake for an interracial wedding? Right. Would the same kind of analysis apply?
The world would not end if the same kind of analysis applied. It's an article of faith on the gay rights side that sexual orientation must be treated exactly like race. And that's just where it's signed at the moment. Every civil rights group that has come along has tried to piggyback on the black experience. And in my opinion, they're not remotely the same. Gays were treated terribly in this country. So were a number of other minority groups. But none of those groups endured 250 years of slavery. None of them required a civil war and 750,000 deaths to change that condition. None of them required 3 constitutional amendments to address the problem. None of them required now 150 years and counting trying to enforce those amendments. Race is unique in our constitutional history. And I'm on record in print as saying it's entirely fine if the court says there's automatically a compelling government interest in race. I don't think that's true of any of the other civil rights categories.
It's interesting in this case that at the lower level, some comments that were disparaging about the beliefs ended up being obviously very important in the later part of the case. In Canada's Supreme Court ruling recently in the Trinity Western decision about a Christian university and its policy about sexual conduct in students, a majority at the Supreme Court used terms like disrespectful and degrading to refer to the beliefs of the school as embedded in its policy. And so I'm curious, in a case like this, how are the kind of details of the person's belief relevant. So you have Mr. Phillips saying, I will serve you regardless of your sexual orientation and whatever services you need. It's just participating in this special ceremony. Do we look at that and say, well, that makes the need for the exemption narrower because it's only discriminating with respect to certain ceremonies. And maybe it's kind of lowering the injury to their dignity where he's saying, look, you can buy any food you want from me or I can bake you things. So I'm not insulting you that much. It's just this. Or is it something else in kind? So like, in other words, this is just narrowing, those facts are just narrowing, or are they irrelevant in some other way?
I think they're relevant because they focus the objection on a context that is of great religious importance in the religious worldview of the objector. Now, it's not immediately obvious how you fit that doctrinally into the way the court has structured the doctrine, but it seems to me it has to matter. Summary statements of Sherbert and Yoder or the actual drafting of the Religious Freedom Restoration Act seem to create two separate inquiries. Is there a burden on religious practice? Well, the fact that it's a religious context goes to the substantiality of the burden on religious practice. That may be a yes-no question the way this thing is often formulated. If there's a substantial burden, then the second question is there a compelling interest to justify it? In practice, I think it cannot work that way. In practice, the substantiality of the burden and the compellingness of the government interest are balanced against each other. And the compelling interest test is really a balancing test with a thumb on the scale in favor of the protected liberty. And the court often talks about it that way. There are numerous opinions, compelling interest opinions, to talk about balancing or weighing. I think that's how it works in practice, whether or not that's how the doctrine is formulated. And the fact that it's a religious context goes to both sides of that balance. It goes to the weight of the religious interest, and it goes also to the weight of the government interest because it narrows the circumstances in which the exemption will be invoked. So I think it's on both sides of the balance. Well, you got a question you're too shy to ask, I'll be around for a few minutes.